Dezi Freeman is dead. 7 months, Australia's largest manhunt, and it finished this morning in a shipping container. Police shot him. And every headline is going to tell you the same thing. The manhunt is over, justice is served, case closed. But that's wrong, because Dezi Freeman wasn't really killed by police. He was really killed by an idea that is spreading right now in Australia, that tells people the law does not apply to them. And when people believe it, this is how it can end. I've been a cop, I've prosecuted cases, and now as a lawyer I defend them. I've seen this ideology destroy people in real time. So let me show you what it is and what happens next under Australian law. Sovereign citizenship. You've probably heard the term. Most people hear it and dismiss it as fringe lunacy, and legally they're right to, but dismissing it as lunacy is exactly what allows it to keep spreading. So I want to explain what it actually teaches, because you need to understand the internal logic of this ideology before you can understand why a man was prepared to die for it. The ideology in its modern form originated in the United States in the late 60s. It grew out of a movement called the Posse Comitatus, an extreme white nationalist organization with deeply anti-Semitic roots. The foundational claim was this: the legitimate American government had been secretly overthrown. A shadow corporate government had taken its place, and every citizen had been unknowingly enrolled into it. A legal fiction, a kind of slave state through their birth certificate. Now the theory works like this. You are born and a birth certificate is issued. That certificate creates a legal entity or a corporate version of you, written in capital letters, that the state owns and controls. This entity is called the Strawman, and the critical belief is this: you're the living, breathing, flesh and blood person. You're not that entity. You never consented to be bound by it, and therefore the laws don't apply to you. Courts have no jurisdiction over you, police have no authority over you, fines don't apply, licenses don't apply, tax doesn't apply. The entire apparatus of the state simply doesn't reach you if you know the right words to say, the right legal sounding phrases, the right paperwork to file, and the magic that sets you free. That's what Dezi Freeman believed. And before I explain why it is demonstrably, categorically, legally wrong, let me show you what that belief looked like in practice. Because in 2019, Freeman attended a Victorian court. Not as a defendant, he went there to perform a citizen's arrest on a magistrate, a sitting judicial officer in their own courtroom. In 2021, he lodged documents attempting to privately prosecute the then Premier of Victoria, Daniel Andrews, for treason. He posted on social media that the only good cop is a dead cop. And at some point, he changed his legal surname from Philby, the name he was born with, to Freeman. He did not adopt this ideology like a hat, he rebuilt his entire identity around it. So by the time those officers arrived at his property last August, Freeman had spent years constructing an alternative legal reality in which that warrant, which was signed and issued by a magistrate and in accordance with Victorian law, was nothing more than a corporate document he had the sovereign right to refuse. Now, why is this legally nonsense? Well, the foundational problem, and it is fatal to the entire theory, is this. The strawman concept originates from the 14th Amendment to the United States Constitution, an amendment passed in 1868 to grant citizenship to freed slaves after the American Civil War. It has nothing to do with Australia at all. It was never adopted here. There was no amendment. It doesn't appear in our Constitution. It doesn't feature in any Commonwealth or state law. Australian contract law, property law, constitutional law, none of it recognises the concept of a legal strawman. It simply doesn't exist in the jurisdiction. So when sovereign citizen arguments have been raised in Australian courts, and they have been raised repeatedly, courts don't engage with them. They dismiss them because there is nothing to engage with. The legal architecture that the ideology is built around has nothing here. There's nothing for it to connect to. Freeman took his arguments to the Victorian Supreme Court in 2024. He lost, not on a technicality, but because the argument has no legal basis. So this ideology was built for a different country, a different constitution, and a different legal system, but it arrived here carrying the foreign DNA. And the people who sell it don't tell you that. And the people who believe it don't know. But here's what I actually want you to sit with, because it's the obvious question, the question most people ask. Who believes this? Who looks at this theory and says, yeah, that's real and I'm going to rebuild my life around it? The answer isn't who you think, and it matters enormously for what I'm about to tell you. So here's something really important for you to understand. Freeman's nephew, speaking to the Sydney Morning Herald in the weeks after the shootings in August, said this. He described Freeman as always trying to find a place or a group where he could fit in, and that Freeman was always upset that everybody seemed to have something better than him. That's not the description of a monster. It's the description of a lonely person. A person who cycled through environmentalism, heavy metal, devout Catholicism, conspiracy theories, always searching for a community, always on the outside looking in. And then the sovereign citizen movement found him, and it gave him exactly what he had been looking for. Purpose. A framework for his anger, an explanation for why the system hadn't worked for him, and that he had not failed, but that the system itself was a fraud. And the community of people in this arena agreed, and that there was a community that existed and a sense of power in a life where he had felt powerless. Professor Josh Roos at Deakin University studied the radicalisation pathways into this movement. He identifies 3 structural conditions that create the entry point. First, regional inequality. The people most vulnerable to this ideology are disproportionately in rural and regional Australia, communities that have watched young people leave, housing that has become unaffordable, jobs that have just disappeared, people who felt that the system, the governments, the courts, the banks have not just failed them, but actively taken their life from them. The ideology doesn't create that grievance, it arrives and it validates it. Second are the trigger events. This is almost always a specific moment, a divorce, a job loss, a financial collapse, a debt enforcement, a custody battle, some direct, personal, painful collision with the legal or financial system that creates the opening. And at that moment of maximum vulnerability, the movement is there, online, with answers, with a community, with a framework that says the system did this to you, here's why, and here's how you can fight back. And third, and this is the big one that changed everything in Australia, COVID. The Convoy to Canberra in 2022 was an inflection point. For the first time, large numbers of Australians who had never previously experienced the law as a coercive force experienced just how forceful the law can be, directly. Mandates, lockdowns, checkpoints, fines, and online, waiting for them, were the sovereign citizens. With a ready-made ideology, with a ready-made explanation, anti-vaccination communities, anti-government communities, and sovereign citizen communities fused that, and the movement grew faster than any previous point in Australian history. So even right now, there are Facebook groups dedicated to this movement with 25,000 active members in Australia alone. There are people selling online courses that claim to teach you how to defeat fines and walk out of courtrooms and assert your sovereignty. It's a commercial ecosystem built entirely on a legal lie. And 6 weeks ago, in February of this year, 2026, the Lowy Institute published a report that should have been front page news. They found this movement is now active in more than 26 countries, and they described it, I'm using their exact language, as an escalating national security challenge, requiring multilateral intelligence coordination between governments. That report was published 6 weeks before this morning. Now here's what I want you to understand about where this ideology came from, because it matters. It originated in America, white nationalist movements in the 1960s, and then it spread, and this is the critical vector, through English-speaking common law countries. Canada, the UK, Ireland, New Zealand, and us, Australia. It's spread through countries that share a legal heritage, because the ideology works by distorting common law concepts, and those distortions travel along the lines of our shared legal DNA. In Canada, it became known as the Freeman on the Land movement. Dezi Freeman didn't just adopt the ideology, he adopted the name. He literally renamed himself after the ideology. A Canadian variant of an American ideology now operating inside Australian law that it was never designed for and has no application to. It is a foreign pathogen in a legal system it was not built for. The FBI have formally classified sovereign citizens as a domestic terrorist threat in 2011. ASIO has named the movement in its National Threat Assessment in 2022. The AFP have internal briefings. The Lowy Institute is calling for multilateral coordination. And yet, most Australians haven't really paid much attention to this movement because it is ridiculous and it seems ridiculous. Most Australians hadn't heard of Dezi Freeman until 2 police officers were shot dead, but the important message here is not that this was a once-off. It's a symptom of a greater disease. So I want to go back just quickly, if you'll bear with me, to the 26th of August. 10 police officers arrive at a rural property in, and I'm going to mess the name up, Popunka. They have a search warrant. It relates to historical child sexual offences. It's a lawful document issued by a court authorising these officers to enter and search the property. So what does that mean? A search warrant is a judicial authorisation. It's not a request, it's not an invitation. A magistrate, an independent judicial officer, has reviewed the stated grounds that the police have and determined that there is sufficient basis to issue the authority. So when police execute a search warrant at your house or your premises or your farm, they are acting under the direct authority of the court, of the judiciary itself. So your legal obligation in that situation is really straightforward. You don't have the right to resist it. You don't have the right to declare the warrant illegitimate based on your personal belief. You can't opt out of a court-issued authority because you've decided the court has no jurisdiction over you, and you cannot meet it with a firearm. Freeman believed none of that applied to him because in his worldview, constructed by the sovereign citizen ideology, that warrant was a corporate document from a court that had no jurisdiction over his sovereign self. So he believed he had the right to reject it, the right to defend his property against it, the right, in his own mind, to treat those officers as trespassers. I want you to understand what happened in the gap between his belief and the law. 10 police officers arrived doing their jobs, lawfully, with judicial authorisation, completely unaware that the man inside that property had spent years building an alternate legal reality in which they had no right to be there. And on the other side of that door, a man who had been told by a cultist ideology, a community, by years of reinforcement that this moment was coming, that the system would come for him eventually, and that he was legally, morally, ideologically justified in what he needed to do. The ideology put a framework around his violence, and it told him he was right, and it told him they were wrong, and it told him the law didn't apply. And 2 officers walked into that gap, and none of them came home. And here is where the story takes a turn that you may not be expecting. Dezi Freeman died this morning. And that means something very specific under Australian law, something most people don't know, and it changes everything about what happens next. So answer this question. What crime has Dezi Freeman been convicted of? The answer is none. Dezi Freeman died without ever facing trial for the murders of the 2 police officers. He was never charged. He never entered a plea. He was never found guilty. Under Australian law, as of this moment, Dezi Freeman is legally unconvicted. There is no mechanism in our system for a posthumous, after-death criminal trial. And when an accused person dies, the prosecution dies with them. The families of those 2 police officers will never sit in a courtroom and hear a guilty verdict read aloud. That's the legal reality. It is one of the hardest truths in criminal law. But here's what will happen. When someone dies in circumstances that are unexpected, violent, or involve police use of force, Australian law requires an independent investigation, not a criminal trial, a coronial inquest, conducted by a coroner, who is an independent judicial officer, whose function is not to convict or acquit, but to determine the full circumstances of the death, and critically, to ask whether anything should be done to prevent similar deaths in the future. A coroner has significant powers, the ability to compel witnesses, to examine government agencies, to scrutinise the conduct of police, and to make formal public recommendations to governments, to institutions, about what needs to change. Now think about what sits in front of this coroner in the future. On the surface, a police use of force incident. Was it justified? The Victorian Police Commissioner said yes. The coroner will examine that independently. That examination matters, but beneath that, and this is what I want you to watch, the coroner will have to confront a deeper question. Why did this happen? What series of events, what ideology, what radicalisation pathway produced a mourning like that of August the 26th. And because Commissioner Bush confirmed this today, what about the people who helped him? Police believe Freeman was assisted during those 216 days. That people provided food, shelter, and support to a fugitive wanted for the murder of 2 police officers. Those people aren't protected by Freeman's death. They can be charged. Accessory after the fact, potentially in connection with the murders themselves. That investigation is active. The case is not closed. But the Coronial, this is the one I want you to pay attention to. So as we discussed, the Lowy Institute 6 weeks ago called for a formal government response to the movement. ASIO has been watching it. Academic researchers are warning about it. And now, in the wake of 2 dead cops and a 7-month manhunt, a coroner has the formal authority to put the question on the record that no government has yet answered. Is Australia dealing with this problem? Is this ideology, this imported, legally baseless, increasingly violent movement being treated as the national security threat that it clearly is? Or are we waiting for the next one? That coronial inquest could be the most important legal proceedings in this country over the next 2 years. Not because of what it determines about Dezi Freeman, but because of what it could recommend about the movement that made him. Which brings me to what I want to leave you with. Because this is not ultimately a story about one man in a shipping container, and it never was. The law in Australia is not a menu. You can't opt out of parts of it. You can't file a document that separates you from its authority. You cannot rename yourself in a way that places you outside of its reach. It doesn't matter what you believe. It definitely doesn't matter what Facebook groups are telling you or what an online course that somebody sold you claimed was legally true. The law applies. Full stop. And yet, and this is the part I can't stop thinking about, the people who fall into this ideology are not, in the main, stupid. Freeman wasn't stupid. He was a man who felt the system had failed him, who found a community that validated his anger, who found a framework that gave him an explanation for his pain and a sense of power and a reason to keep fighting. The ideology did not create his anger, it weaponized it, and then it pointed it. This is what makes the movement dangerous. Not that it convinces people of stupid things, but that at the exact right moment, the moment of maximum vulnerability, it offers something genuinely hard for people to resist. The feeling of power in a life where someone has felt utterly powerless. Freeman changed his name to Freeman. He didn't adopt the ideology, he built an identity around it. And that should tell you something about the nature of what we are dealing with. This is not a hobby. This is not a substitute for meaning. And as it grows, as 25,000 Australian members become more, as an online radicalisation accelerates, as the movement fuses with other anti-government forces, the violence will not stop. The Lowy Institute, ASIO, the AFP, researchers at universities across the country, across many countries, they are all separately arriving at the same conclusion. This movement is escalating, and Australia does not yet have a coherent national response to it. I hope the Coronial changes that. I'll be watching it, and I'll report back on this channel when it does. 2 families are missing something tonight. Neil Thompson and Vadim Devort went to work on a Tuesday morning with a lawful warrant, doing their jobs, and they didn't come home. They were killed by a man whose belief system told him they had no right to be there. And that belief system didn't die today. It believes it has a martyr. It has a name, it has a community, it has a recruitment pipeline, and it will find the next person who is angry enough, isolated enough, and desperate enough to take the ideology to its own twisted logical conclusion. Dezi Freeman was not an anomaly. He was a warning. The question is whether anyone in power is listening. I'm James Glissan, and if you want to understand how power actually works in this country, I will see you in the next one.